Well, thank you so much for joining us today for today's event, a free 60-minute lunch and learn, data analytics in the courts, essential information for an emerging generative AI function. We have an expert panel today of former and trial court judges featuring Judge Ron Hedges, Judge Jennifer Mabey, Judge Xavier Rodriguez, Judge Scott Schlegel, and Judge Sam Thumma. We're going to discuss today in a round-robin, fast-paced manner the transformative power of generative AI in litigation and explore the latest tools and technologies that are reshaping the legal landscape. Today's webinar is a presentation from the ABA Task Force on Law and AI and its working group on courts and AI. We're going to invite all of our panelists up to the stage here to go ahead and introduce themselves, and then we'll jump right in to today's event. Judge Mabey, why don't you get us started?
Well, welcome, everyone. I'm happy to be here. My name is Jennifer Mabey. I am a state district court judge in the state of Utah. That's a court of general jurisdiction. Recently finished up a 4-year term as presiding judge in our district, which is what gave me an opportunity to look at data analytics and the advent of AI and its effect on our operations in the court. And so I'm excited to be here to have this discussion today.
Next on our panel today, we have Judge Ron Hedges.
Thank you very much, Joey, and thank you and ABA for sponsoring this today. My name is Ron Hedges. I served as a United States Magistrate Judge. I sat in Newark, New Jersey for over 20 years. I am a member of the New Jersey and New York Artificial Intelligence Task Forces, and I write and speak in the area. Again, so thank you for having us today.
We're so excited to have you here. Next up, we have Judge Xavier Rodriguez.
Hi, and thank you for the invite to be here. I'm a United States District Judge for the Western District of Texas. I've been in this job for about 20 plus years. Prior to that, I was a justice on the Texas Supreme Court. I'm an adjunct professor at St. Mary's School of Law teaching e-discovery, and I also serve on the Texas State Bar AI Task Force.
Thank you so much. And rounding out our panel today is Judge Scott Schlegel.
Thanks for having me, Joey. Good to be with you all. My name is Scott Schlegel. I am a judge on the Louisiana Fifth Circuit Court of Appeal. That is the Louisiana Fifth Circuit. But if anybody knows President Biden, U.S. Fifth Circuit sounds good to me. I serve as the chair of the Louisiana Supreme Court Technology Commission, and I'm also on the ABA AI Task Force. So I'm looking forward to this conversation.
Fantastic. Well, we're going to go ahead and get started with our first speaker today. So Judge Mabey, go ahead and get started whenever you're ready.
Great, thank you. So my topic today is on the scale or on the spectrum of data analytics and AI and generative AI, but it's going to be a little heavy on the data analytics side, but there's a tie-in if you'll just bear with me. So my topic today is involving a pretrial risk assessment tool that the state of Utah has implemented that should be coming up on your screen. This is called the Public Safety Assessment Report, and it's a tool that was developed by the Arnold Foundation. I was on the panel or the committee that took a look at this tool and made the decision to implement it in the state of Utah for judges to use in making pretrial release decisions. And so when anyone is arrested in the state of Utah, well, the majority of them will have this document reported. There are some times where it doesn't generate because we just can't get the data that's necessary to go into the algorithm. We'll talk about that in a moment. But when a judge is making a pretrial release decision, they generally have this document available to them, and this is the first page that they see. I've redacted it, obviously, to make sure that there is no identifying information here, but this is a sample, not a sample, but one that was generated for a defendant. You can see the date here on the screen, arrested on June 7th, so just 10 days ago. The scores that are generated here give the judge a prediction or a predictor of the likelihood that this individual is going to engage in new criminal activity. This particular one is a 6 out of 6, so that's the highest score that this individual can achieve, and higher is not better. Higher is the fact that it's as high as you can get on this risk level score. 5 out of 6 on the failure to appear scale. And so this is what the judge sees in making a decision along with the affidavit of probable cause. These scores are based upon an algorithm that utilizes the 9 risk factors that are listed there toward the bottom of the screen. We have the first one, age at current arrest, and I've redacted that as well, just because, like I said, I wanted to be very careful here. But I will tell you that in this particular individual's score, their age was over 21, which has, based upon all of the data analytics that we have, that is a risk factor that was identified. If this individual was under the age of 21, the risk factor is actually higher than over. The next one on the risk factor you can see there is whether they have whether the current offense is a violent offense. Whether there's a pending charge at the time of the offense, this one is a yes. Prior misdemeanor conviction, prior felony conviction, prior violent offense, prior failure to appear in the past 2 years, prior failure to appear older than 2 years. And then Joey, if you can skim down just a little bit, we get that 9th one. Whether this individual had received a prior sentence to incarceration. And so our tool pulls from all of the data that we can find through our system. It's called UCGIS, but it's very similar to most state systems where they not only gather information within our state, but also nationwide from the various databases. And they gather the information, apply it to the algorithm that has been established for this tool, and that it comes up with recommendations based upon that the judge can take a look at. And so the recommendation here that you're seeing on this first page, because of how high this individual's score was, is that they be released with what's called a PRL5 condition. And we're going to talk about that in just a moment. And so prior to implementing this tool, judges had to make a decision on bail with almost no information. They didn't have criminal history explaining the number of prior convictions. They didn't have any information about prior failures to appear. And so this was intended to provide the judge with additional information. So it's not a decision-making tool in terms of the algorithm makes the release decision. It's really intended to be a tool that gives the judge more information with which to make his or her determination as far as pretrial release. If we'll skim down in the second page, Joey, just down past the charges, this is just a visual representation, this scale here of where the individual falls on the various scale of, going from a 1 and 1 on those 2 risk levels, all the way to a 6 and 6. And so it kind of just gives it another way of seeing the information. And then below that, we have the various pretrial release conditions. And I'm not going to go through those in specific detail, but I will just indicate as you increase on the risk scale, the intensity and the level of the pretrial release conditions also increases. And so this is a tool that, like I said, is really heavy on the data analytics side, but it gives us some information and some a springboard, I think, in going into AI in terms of how we can use that to better analyze the data that we have, but then also fill the gap when it comes to pretrial release conditions and how AI can be used, for example, to put some of these conditions into place when we have jurisdictions within the state of Utah that don't have specific pretrial programs in place. And that's become really important. And I think the reason that the data is so important now, and actually, Joey, we can take that down because I don't know that it's going to really be as important to our discussion after we've already laid that foundation. But what we found is that the PSA is having an impact on judicial decisions as far as pretrial, but those decisions are pretty closely tied to whether there is a pretrial services program in place. There are several jurisdictions in Utah that don't have a pretrial program at all. And in those locations, people are being treated differently in terms of the release decisions, because judges who don't have the pretrial services available to them are more likely to hold without bail or to do something other than the conditions that are recommended, because they just don't have them available. And so I think the important part of this discussion is how can we use AI to fill that gap so that we're getting the benefits of more informed decisions as judges in terms of the pretrial release conditions that we're putting into place, because we can actually fill the void of having those conditions available. And the data is also very suggestive of the fact that if we can implement pretrial conditions, that we're getting some pretty good success rates. We've had one of our jurisdictions, it's the largest one, has a pretty significant success rate in the pretrial stage of reducing the failures to appear and reducing the number of new crimes that are being committed while people are out on release. Another rural county that just recently implemented them showed a reduction of new charges. They had been tracking, and they had 50% of their people out on pretrial release were committing, not pretrial release, just out of jail, were committing 50% of them were committing new crimes awaiting adjudication, and they were able to reduce it to 10%. So I don't want to throw out a ton of numbers to you, but I think the important part of this is that AI can fill a void here that will treat people based upon their actual risk to the community, and do it in a way that is not dependent upon the fact that a county has a pretrial release services program in place. Maybe we can fill the void with AI. And so I'm going to leave it there. I think that there are some other questions that we can flesh out, but I'm just kind of, I think, setting the framework for a discussion of how AI could be used in this situation to fill that void and to build upon what we know works. But maybe it's a financial decision that we can't fill it with physical bodies. Maybe AI can fill that void. And so I know that Judge Rodriguez may have some thoughts on that. And so I'm going to turn it over to him.
Yeah, no, thank you. And so I agree, you know, there's a use for these kind of predictive tools. We saw a couple of years ago where a program called, or a tool called Compass was being used by some states to determine bail decisions. And then over the weekend, I was struck by an article I saw in the employment context, civil rights groups complaining and advocating against the use of AI tools as employment screening devices for hiring purposes. You know, the judge has been talking about the use in the criminal context, but, you know, we need to start thinking more broadly than that about how these things are being used. And we got to be concerned. And so in part, those civil rights groups have some validity to the concerns. The Compass system I talked about, first of all, it's a couple of years old. And so in terms of AI tool worlds, God, that's like eons ago. So I don't think we can be comparing those old early version of tools to what's currently being done with AI. That's point number one. Point number two is we got to be concerned now going forward basis. How is the AI tool being populated? What's the source of the data? The problem with Compass several years ago was they ingested a whole bunch of data to determine whether or not a criminal defendant was going to be entitled to bail. In the ingestion process, zip codes were brought into the system. Compass learned that, oh, well, zip codes, if a person lives in this zip code, it's a high crime rate area, and so we should deny bail based upon these problematic zip code areas. Well, as we all know here in the United States, oftentimes there's a correlation between zip codes and race. And so it turned out that Compass was actually predicting for Black defendants charged with more serious crimes and who had a lesser criminal history, but who lived in certain zip codes, they were being recommended for denial of bail, whereas white defendants who lived in not those zip codes had greater crimes being charged and had a greater criminal history, were being recommended for bail. So we got to be concerned about how these programs were developed. And so that goes to a question actually that Raphael's posing here in the Q&A. So in the criminal context, do defendants need to know the source and veracity of these reports? That becomes a little problematic. A lot of these tools, Compass at least was a proprietary tool. So there's the challenge of prying open those proprietary concepts. These AI tools, if we're going to use them, they're going to need to be a little more just transparent about what is being ingested into these systems. Problem number two, from a technology standpoint, is in this black box, even though we may know what was inputted and how the algorithms were developed, as the tool starts learning in itself, there becomes a black box problem. We're not sure completely what's going on in the black box. Now, all that's to be said, that doesn't make me a critic of these tools. I think they have a lot of value. Judge was mentioning that prior to this tool of theirs, they didn't have any data. So having data is generally good. We ought to make sure that it's good data, but it's better than no data. And then to some of the civil rights critics and all this that are concerned about bias, and I understand the concern, what's the alternative? There's humans in employment, there's humans behind the bench, and there's always the possibility of bias there, whether intentional or unintentional. So I think, bashing these tools prematurely, if they're just used as a tool, these things should never be used as a final decision-making authority. And I don't think any of us are advancing that. So, but basically it's garbage in, garbage out for all these tools, whether we use it for something like bail decisions. But let me turn to what I was asked to speak on in court data analytics. And so, a lot of tools out there by some providers are arguing that they can sort of predict what judges may or may not be able to say on a given case. Interestingly, just over the weekend, there was an article published saying that they used Claude to analyze the last 35 or so Supreme Court cases, and that the use of Claude without a lot of, so normally we're all concerned about the prompts and how did we develop the prompt. With little prompting, Claude was able to accurately predict the outcome of 34 of 35 of the cases, and the one it got wrong actually was a 5-4 decision, and Claude agreed with the dissent. So, maybe there is some predictive value to all this. That said, I question that. So we provide in the federal court system a lot of data to our administrative office of the courts. Not all the data is good, not all of it is current, and that could lead to skewed results. A lot of these predictive tools say, oh, well, you can determine how fast your judge is going to resolve the motion. Well, I question that. If we're just looking at the motion filing date, that's not telling us when the motion actually became ripe. Did the parties engage in settlement discussions in the interim and ask the judge to pause on a ruling? Did we offer extensions of time to engage in additional discovery before a ruling? So, all those kind of factors skew the data analysis. even favorability factors. Sometimes they say, well, we can predict whether the judge is going to favor plaintiffs or defendants. Well, if we're not skewing out for certain legal factors, so for example, in Texas, judicial foreclosures are not necessary. Foreclosures can be done without a judicial order. But when we get mortgage foreclosure disputes, because of diversity jurisdiction, granted, the state of the law is such that, well, if you didn't pay your mortgages, you're likely going to get foreclosed. If we're looking at stats like that in the aggregate, are we going to say some judge is just now defendant friendly? So we got to be careful about what we're looking in this data and how we're interpreting it. But all in all, data is good.
All right, thank you. I think we're going to bring up Judge Ron Hedges now.
Okay, I'm trying to get my video started. There I am. Again, thank you for having us today, and all of you, thank you for listening to us. I'm going to spend a couple minutes talking about predicting outcomes or predictive analytics. And I think as we begin this discussion, we need to differentiate between artificial intelligence and generative artificial intelligence. We've been using artificial intelligence for a long time now, relatively speaking. If you are doing some type of research on the internet, you may just be going through a large data set that's going to be spewing out information for you, as opposed to generating or creating things. But I think our focus today probably should be on generative AI, because that's where a lot of the analytics are coming from. We could ask a platform, whatever the platform is, give me every decision in the United States, going back to what Judge Rodriguez mentioned before, where a plaintiff prevailed in X case. But we want to go beyond that and say, give me every decision in the United States, and based on that, give me perhaps the most optimum argument to make with regard to winning or with regard to losing. And we could spend a great deal of time talking about prompt engineering and how one goes about asking questions like that, although we don't have time to do it. And Judge Schlegel, one of our co-presenters, had an excellent blog this morning where he talked about things to think about when you are making queries or submitting prompts for things to be talked about. But one area I mentioned before, or mentioned now, was in predictive analytics, risk assessment. We as lawyers have done that for a long time, but now we have a large database and we have an AI platform that can help us with that. It's also used a lot for legal research. And Judge Schlegel and I, if we have time later on, can talk about that as a proposition. But I think it's fair to say that a number of attorneys are looking to generative AI programs to help with research and the like. Every legal research platform I'm aware of now has a generative AI tool in it, where instead of just asking for information to be put in a column, if you will, asks for some predictions about what are the most important decisions here or the like. And I believe Judge Rodriguez talked a little bit about that before. You can also use generative AI or AI to review contracts. If I am being drafted to ask a contract, to write a contract, and a question of what's the best statute of limitations might be, I can query a generative artificial intelligence platform. It can go through X number of contracts out there, and being creative can suggest what the best term should be that we want. It's also used, generative AI is also used for brainstorming. That kind of picks up what I mentioned before with regard to predictive analytics. You might get a response from a database after you put in a prompt, and that may lead you or others to further queries in the database to see what argument might be the best. And for example, in closing argument and the like, we do have a matter pending in the United States District Court for the District of Columbia, where the defendant is arguing ineffective assistance of counsel because it is alleged that his attorney resorted to a generative AI platform to write a closing argument. I don't know whether that happened or not, but obviously it's an area for brainstorming if you're trying to put an argument together. And then, of course, summarizing legal narratives, I think that goes back to what Judge Rodriguez spoke about before too, where a platform is reviewing decisions from the United States Supreme Court, perhaps summarizing different narratives there or making predictions, and this is pulling everything together, about what might happen in response to this query going into the database. So I think there are a number of things we need to think about when we're using data analytics and predicting outcomes. Number one, what is the platform we're using? Where is the data set in that platform coming from? Is it scraped off the web? Or is it more a limited database? And some law firms now, because of concerns about confidentiality and the like, are creating databases and generative AI platforms in-house. So there's not that much of a concern about information going out to the public. That's number one. And number two, learning how to do prompts. I'm sure Judge Rodriguez's law school, as Georgetown is, where I went, is offering training to law students on prompts and among other things to do. We know anecdotally that a lot of firms are using new associates or training new associates on prompts. And I think I'd say we're just at the beginning of how law firms and legal departments in entities are going to be using generative AI to make predictions. And Judge Thumma, I don't know if there's anything you'd like to add to that before we go ahead. Nope, haven't
Ron,
heard
my video, yeah, here it comes. No, thank you. And again, I'm sorry to have joined this late, given technology gives and technology takes away. And one of the things it took away from me was scheduling this morning. But you're absolutely right, Ron. And that's from the lawyer perspective, right? And then we got to figure out, okay, what are courts going to do, and what courts should do, or should they do with generative AI? You know, Jennifer has started with a delightful description of a risk assessment tool, which is not yet generative AI driven, but there's the potential for that. And then there are extraordinary questions about what courts should be doing with generative AI. This Thursday, I'll speak to our judicial conference for judges on generative AI. And I'm sort of guessing that, like in most rooms of lawyers or judges, probably 20% have goofed around with, and I do mean goofed around with ChatGPT or its equivalent. I'm not behind the paywall on those. I use my 4 questions in the day and then go on to do other things, and I don't do case-based things. But I do that to get a feel for what it is and what it isn't. And one of the things that it's not really yet is replicable. If I put precisely the same search in with exactly the same punctuation, even almost minute to minute, I can come with different things. I can get different responses, and that's not very satisfying, right? You know, we're used to those, you know, Westlaw searches that if I do them today and in the morning, I'll get the same things in the afternoon. And that's not what we're seeing always for generative AI. But there's extraordinary power, extraordinary mischief can be done. We may talk about that in a little bit. But I tend to be a generative AI optimist, just given the power it has to do things that we as people haven't done and can't do in a way that I hope can make things better for access to justice and for us all. Thank you, Ron. Now, Ron, do we go next to Scott? I think he may be, and Scott, I will commend all the panelists. They're just first rate, and I was so delighted to be able to be a part of this. And Ron, you mentioned Scott's blog, and it is worth the price of admission for sure. And Scott, thanks for doing that. That's not an easy thing to sort of have the discipline to keep up to speed on, and you're making us better, and I appreciate it.
Well, thank you for that. And since we're talking about Gen AI makes it possible, because I certainly could not be writing all of those articles without the assistance of Gen AI and LLM. So let me kind of dive into the whole, data analytics side of it and kind of mention a few things that a few folks touched upon. This notion of predicting judges' decision making and the outcomes. I mean, look, if you're a lawyer, and everybody here is a lawyer, we've done this before. We've done it since the beginning of time. You pick up the phone and call your colleagues. You shoot an email saying, "Look, what's Ron gonna decide on this case, or which Judge Rodriguez is gonna decide on this case?" And we've done it for years and years and years. But with this new Gen AI tools and all these different tools that are occurring, Judge Rodriguez mentioned, I'm gonna have to go look it up, that Claude was able to successfully determine the outcome of the Supreme Court decisions without much prompting, which is very interesting to hear. And my initial reaction to that when Judge Rodriguez brought that up was, yeah, but every Supreme Court case is reported. And then we got into a brief discussion about federal courts versus state courts. And even in federal courts, most of the district courts and the trial courts, they have to give reasons for their judgments. And you can find all that in a readily available PACER system. What about state courts? Judge Mabey and I are state court judges. And, when I was on the trial court for a decade, 95% of what Judge Mabey and I do is not reported. You just don't see it. And if we do make a decision on a motion for summary judgment or a motion in limine, unless the participants request reasons for judgments, typically it's an oral recitation of the reasons on the record. And you're never going to find that. And, a lot of state courts still don't have e-filing and electronic records. So I guess my point to that would be back to the whole notion of garbage in, garbage out. These AI tools and the predictive nature is all based upon the data. So as we're going down this road, the more we can get files and decisions and all the data in an electronic format, the much better we'll be able to use these tools, and the much more predictive I think that they'll be. Judge Hedges mentioned the article that I wrote this morning. And what I said was, using an LLM is like going to the Cheesecake Factory and ordering a meal. And what do I mean by that? If you've been to the Cheesecake Factory, that menu is obnoxious, right? It's 30 pages long. You can order anything that you want. And if you go into the Cheesecake Factory and you ask the server, "What do you recommend? I'm really hungry." And the server says, "I recommend the filet or the ribeye." And you go, "Oh, it's 9 o'clock. I can't eat a ribeye that late at night. How about something else?" And they say, "Well, how about a little crawfish etouffee for dinner?" "I'm allergic to shellfish." The point is, if you don't give the server any information, not the server and the LLM will give you back something that may not make any sense. And so the more prompting that you can give these LLMs, ChatGPT is the Kleenex of LLMs, or Claude, the better the output will be. And so how do I use this, or how would I use this as a lawyer? And we have a question here about the jury selection process. And yes, I've heard that there are actually tools that are being used and developed for a jury selection process. But how do I prepare for a jury trial? It might be late at night and you might be alone, and you might want to have a conversation with these LLMs, and you can actually, again, assuming that you know how to use these properly and you've addressed all the privacy and confidentiality issues, you could actually ask the LLM to be a juror and say, "Hey, look, you're a jury of your peers. I want you to act like 12 different people from our community, and I'm going to give you a fact pattern, and I'm going to ask you, what would you decide on this case?" And what you'll find is it'll give you 12 different reasons or 12 different explanations of why it thinks that you will prevail in your case or not. And it's just an interesting way to go back and forth and discuss this with folks. There is a question here about transcriptions. I, like the person who just spoke, I hired a stenographer. I want that person, in the courtroom doing it all the time. But the realities is sadly, it's becoming a lost art in a lot of jurisdictions within the state courts. And so how do we use these technologies to do a better, and I don't want to say better job, but to supplement where necessary? There's someone just suggested human in the loop. Always have to have a human in the loop. And, with these transcription tools, there are a lot of times in court, and I'm just going to give you a few examples. There are a lot of times in court where you come in for a hearing and the lawyers are told what the answer is. The judge says, your motion is granted and gives you a few reasons. And the lawyers walk out the door and say, what did the judge say? There are tools out there that we could easily use to modify and say, have a transcription. As soon as you walk out the door, the transcription is sent to the lawyers. It drafts an order saying exactly what the judge said, that the human in the loop, the lawyers can get together and actually they know what the judge said. The order's already prepared for them. They can go, yep, no, we agree, send it into the court certifying that all parties agree, we're done. That is a great use for generative AI tools. You can do the same thing with plea forms. If there's somebody that's there to tender a plea of guilty, we could build tools out that know the sentencing ranges for all the different types of crimes and pre-fill out all these forms to set ahead of the game. Time studies. If we layer these generative AI tools on top of these live transcriptions, there is a great chance that we'd be able to determine how long it typically takes for these types of hearings or those types of hearings, to do weighted studies to determine, do we need more judges in this jurisdiction, less judges in this jurisdiction, so on and so forth. So there are a lot of great ways to use these types of tools to benefit the courts. And it just takes a little bit of thought of how we can use them. I always say, look, LLMs are just like any other technology. It's just technology. We are the subject matter experts. We are the experts in workflows. And if you really, really understand your workflow and you develop the partnerships with everybody within the justice system, then you can pick your tech stack. And I think if you do it in that manner, as opposed to just saying, ooh, Gen AI, let's layer everything on top. I think if you do it in the reverse and say, partnerships, understand your workflows, then pick your tech stack, I think that we will be in a much, much better situation going forward as the courts and as the justice system in general, utilizing these tools and realizing they're just tools. You're the lawyer, you're the judge, you're the court. We really need to understand how to use all these things. I could go on, but I will pause for a moment and see where we're going from here.
Scott, thank you. And let's open it up now for questions. And this is kind of an all skate, particularly, we have a dichotomy: trial judges, appellate judges. And Scott, you have one foot in both rooms, which is great. Have you, on the predictive side of AI, how have you been seeing it used in the process of jury selection, which suggests that you've seen it in the process of jury selection? I just don't know the answer to that, but let me look to Scott and Jennifer and Xavier and Ron, if you've seen it as well. I have not, but I haven't presided over a trial in about 12 and a half years. So it's not a big surprise.
So I haven't personally seen it. I've read that lawyers are starting to use Gen AI to do much more predictive. Again, it's just kind of how you were doing it now, but they're now layering the LLMs on top of it. They'd go in, they'd get the information about the potential jurors. You'd have the jury selection experts sitting there with the lawyers and using all the information and predicting who would be the best juror for that type of case. My understanding is that there are firms out there that are now layering LLMs on top of it to assist them in their quote unquote areas of expertise in picking a jury. As a former prosecutor, picked tons and tons of juries, and I don't know that an LLM is going to do any better.
Yeah, I was just going to let me chime in on that too, because what would really be interesting is if we had actual data from jurors who actually served, and we could get the demographics and all that, and then know how they ruled and what, if any, monies they awarded and how much. But we don't have that kind of data. So I'm kind of suspect because, going back to the adage, garbage in, garbage out, is any information helpful? Yeah, but I'm also questioning this one.
Jennifer, what do you think?
So I haven't actually seen it in my court, but I can see the direction that it's headed, because when we moved to virtual jury selection, we use WebEx. We started utilizing questionnaires that get sent out to the jurors in advance. Those responses are provided to counsel in advance, and it allows them access to a lot of information that they wouldn't have had until the day of trial, right? Now that information is available to them to feed into tools that are created to kind of give this predictive analysis. And so I can see it looming on the horizon, that that's going to be a more common practice.
Ron, anything to add on that?
My one comment on it, going back to what Xavier spoke about before, with regard to a platform using a zip code to identify someone. There's a lot of potential for bias when you're using these large language models. And I'm not sure what you can do about it, other than look to see how peremptory charges are exercised and set up a Batson hearing someday if there's a problem there. But every technology is good and bad, Sam.
Well, you're right. And courts collect an enormous amount of data, right? We just absolutely do. Now, whether we do it right or not, different question, because there's always concerns about quality of data. Whether we're capturing the right data or not is always up for debate. The National Center for State Courts on the state side has done some great work on that front. And then whether we're reporting it out in a timely fashion in a way that folks can actually use it. Arizona has a data dashboard that our Supreme Court keeps. It lags in time. It's not instantaneous. It may not keep the right data, but it's out there, and if is a target to shoot at, if nothing else. But it doesn't get as granular perhaps as it should. So next question, let me toss this one out, because it's a permutation on something we've seen in federal courts on certifications by lawyers. That's a topic of a different lunch and learn in the past. But with the rise of generative AI, there also has been a rise of products that seek to classify whether a piece of work was created by generative AI. And the question is, do those tools have any place in the judicial process from the bench's point of view?
Yeah, so I see a lot of value there as we're worried about deepfakes. There are a couple of things that have been going on. And so one, we may see some regulatory activity. There's a lot of push now for AI developers to embed watermarks into their product, so we know that the exhibit was actually created by AI. Now that helps us with whatever is real AI generated exhibit, but and so people smarter than me say, hey, well, these people were really smart, we'll just deep fake the watermark. So I think we're always going to be going back and forth. It's almost like viruses, right? We'll always be playing catch up. But these current tools are purporting to state that that they're developing, like on video, they're monitoring facial tics, breathing patterns to determine, and they're using AI on all that to determine whether or not the video is personifying what would be real. And so I think there will be some value. Whether they're as accurate as they claim to be now remains to be seen, but I'm sure they're going to get there.
I'm going to step back a little from what Xavier said and raise the specter of expert opinion having to come in this entire area. There's one decision that's come out from Washington State a couple weeks ago, and Washington State is a FRI jurisdiction. It's a little different than just about everywhere else, but we're going to have a rise of experts, I assume, that are going to be able to talk about the origin of the platform to some degree, and talk about whether whatever is created is a reasonable facsimile, whatever language you want to use, a depiction of something. And that's going to bring in discovery issues, I would expect. And it's also going to bring in admissibility issues. And I think Xavier and both you and you too, Sam, raised the question of what judges are going to do about this. I'm not a fan of local rules or chambers practices that say attorneys and pro se's have to identify what they used or whether they use generative AI. Interestingly, Xavier's circuit was proposing a rule like that and just withdrew it a week or two ago, saying that lawyers, you have your obligations, comply with them. I think we're going to see a lot of that in the next year or two, as how courts are going to respond to this.
Yeah, I mean, as we said, we could talk forever about deep fakes and everything else. And I'm going to quickly bring it back to data analytics based upon two things that you all said. Xavier, you mentioned they're looking for the ticks and the breathing. I've actually seen a product that, from an analytics perspective, that they have developed the ability to feed depositions, even during live depositions, and actually know the facial values. They start assigning values to the breathing patterns, whether you look left or right, based upon all the FBI's metrics, to determine whether or not the deponent is lying or not, so that it triggers the lawyer to ask and dig deeper into that issue based upon the scores that they are getting from the deposition, which I find fascinating. And would love to hear how that tool is going to be used and utilized. And there was another mention about the ability to, yeah, the ability to use all these different products during trial, you know, whether or not we would allow these types of things, you know, the truth meter, you know, and whether or not you're going to allow detectives to use these truth meters. And it's, you know, it's just a fascinating thought process. And, you know, the Minority Report will be here before we know it.
So let me turn to the next question, and it's really related, I think, Xavier, to a point you made. What about transcriptions of proceedings done outside the court setting, like depositions, where court reporters are currently serving as the only disinterested parties in the room? To me, just at the outset, the parties have some control over that, right? I mean, how they're going to have the record made of a deposition. And Xavier mentioned court reporting services. I'm the biggest fan of court reporters on the earth. I think it's a hard job. It's physically a hard job. It's a taxing job. I had great court reporters when I was a trial judge. Arizona has 15 counties. Before COVID, we had at least one county where there was an unfilled vacancy for a court reporter that had been out for more than a decade. And so I chaired a task force keeping the record by electronic means. What would we need to do if we were recording court proceedings and having them transcribed later? Far from ideal, man. I've seen the transcripts of my hearings when I was a trial judge. When you talk fast, it is a far better product when you have a court reporter there. But if you're taken into custody and need an initial appearance hearing, you don't have 10 years to wait. So we needed to figure out sort of how to do things differently. And that was before COVID and before generative AI. So, you know, technology is far from perfect. We have all learned that during COVID, but it creates some opportunities when, you know, failure is not really an option in that setting. So I think that as to that question, you know, you need to have some confidence level. Some brave set of attorneys will try that at some point. I don't think they're there yet on how to make the record, but I remember back in the day when it was, you know, blasphemy that you could video record a deposition. So I'm just an old man at this point.
Yeah, there's also discovery, you know, and how data analytics will be in discovery. And the scariest thing, I haven't seen it actually played out yet, and I probably shouldn't say this with so many lawyers on there, but my understanding appreciation is these tools are getting so good that even if you redact out the information, that you can the tools can actually predict what has been redacted and actually unveil the redacted portions of it simply because it knows what next word you just redacted. I have not seen it live, but I'm scared to see that in real life.
So the next question, and this may actually, much of this may be invisible to us judicial types, but is generative AI, are you seeing generative AI used with any frequency in mediation or arbitration, like for damages values? That's the specific question, or otherwise. And I sure have not.
I have not seen it, but there is a organization of mediators or neutrals out of Silicon Valley that published some guidelines for the use of AI in alternative dispute resolution proceedings. I expect we'll be seeing more of that as time goes by.
No, absolutely. I mean, it certainly will be able to, you could imagine it from a circuit court perspective, building an internal LLM and doing 30 years worth of data to say, hey, what's a, added or remitted or motion here? What's a C5 worth? I mean, you can certainly see how that could be used and easily done. I mean, that would be very simple to take awards and predict what a likely award is, or what's a reasonable range of an award for a C5 injury. I mean, that could be done today if it's not already been done.
One interesting issue, and I don't have an answer to it, and I just pose it out there, is that have judges, neutrals, mediators, arbitrators going outside the record to decide something. Just an ethics question. Law school would...
Xavier, you're right, and where I've seen that the most, honestly, and I won't name names, but is in federal appellate court decisions, where you'll see, well, clearly it could have, the defendant could have gotten from here to there shorter, see Google Maps, and what it's like, wait a minute, that's not what we're supposed to be doing. So, but it happens, and it's tempting, and this makes it even more so. So let me ask a couple, and I'm going to rephrase these, that they're in the chat, but hey, we're talking about bias in LLMs. Do we not have human bias? Is human bias any different? And then a related question is about privacy rights and things like if anybody's using generative AI to look at facial tics and breathing patterns, is that sort of going deeper into somebody's privacy interests than it should? And those are two different questions for sure, but let me toss the ball up in the air and let you take it.
Well, my thought about looking at physical characteristics, that's biometric information. And there are a number of state laws that address that. Now, I don't know how that would fit in to one of these tools being used in litigation, but Xavier's state, for example, Texas, has a strong biometric privacy law now. And I don't think we're going to be seeing much on the federal level other than health related. But I have to think about how the privacy laws would interact with what we're talking about.
Judge Mabey wanted to get in here.
Well, mine was more on the bias side of things. And I guess it kind of feeds back into talking about the PSA and Judge Rodriguez's comment is that, yes, we all have biases, right? But I think that the important thing is we can kind of train for that. We can try to root that out from a human perspective. The difficulty in the AI is even knowing it's there, right? And trying to create a tool that doesn't skew the responses that we're relying upon. And so, yes, the biases exist, but I think the problems that are created by biases in the generative AI model versus the human model are significantly different.
To me, there's some value in these tools. Just because I start from the proposition a human is always the final decision maker. But like in this PSAR, if the tool is saying we recommend bail, and the magistrate was, oh well, I'm not sure about this, perhaps the tool will advocate for the magistrate to give another pause and reconsideration of his or her decision not to grant the bail in the first instance. So, people focus on the negative. There could be positives to all this.
So we have a little more than 3 minutes. So I'm going to go around the horn real quick for closing thoughts. And Jennifer, I'm going to start with you, given that you gave us such a delightful foundation to build on with the risk assessment tool.
Well, final thoughts are that it's scary, it's exciting, it's challenging. I mean, as I've delved into this, I just feel like there's so much potential here, but I think we have to be very careful as we march forward. It seems to be moving at light speed, and keeping up with it, I think, is a challenge for the courts. But I think that used properly, we can all benefit from AI and how it can make our jobs more efficient and more informed. And so I'm excited to be part of the dialogue.
Jennifer, thank you. Thank you. And Xavier, thank you for joining us as well from the federal bench. Let me look to you for closing remarks.
So, I think whether it's for analytics or for actual work product, it's an exciting time. I recognize the concerns. I recognize what we need to be checking. I recognize that there ought to be a human decision maker at the end. But, I'm playing right now with a couple of tools. One is you upload the system, or you upload your file into the platform, and it's amazing how you type in as your traditional judicial opinion, and then all you do is highlight a few words in your paragraph, throw that into the AI tool, and it automatically searches, prioritizes the sites. And so there's no more hunting through all the boxes and all the depots to find the pinpoint sites to verify that. I mean, there is a lot of value in some of these tools. And so we ought to be concerned about some, and for others, bias doesn't have a factor in what I just described. So we can't be, my final piece of advice, don't throw a broad brush onto all these tools. They're used for different purposes.
Well put. Well put. Scott, you're kind of our line leader from the AI task force for the ABA. What are your concluding thoughts today?
Get involved and be part of the conversation. The train has left the station, and the data and the type of data and how we analyze the data is going to happen. So, I see a bunch of court reporters on here. I see, a bunch of lawyers and different judges. If you're not part of the conversation, when the train lands in the other station, you're not going to have much to say anymore, because, you weren't part of the conversation that's molding where this is going. So start playing with it, start, goofing around with it. I heard somebody say earlier, and, just understand it's here in everything. I mean, medical decisions are being made, x-rays are being read, look at it in your normal life. It's everywhere. So just be part of the conversation. And a bunch of y'all had mentioned my blog post. If you just go to judgeschlegel.com, they're all there, and you can find all this stuff.
Thank you, Scott, and thanks for all you do and your leadership and all of this. And Ron, to you finally.
Fast, because we're out of time, Sam.
Well,
How's
thank
that?
you. Thank you, everyone, for attending, and thanks to the panelists for such a terrific job. And this is part of an ongoing conversation for sure. So get involved, as Scott said, and we look forward to that continued conversation at a future time. Take good care.